Are you able to hear me, Shika?
Yes, Sharmila.
Yeah, we can hear you. It's audible.
Okay, excellent. So hello to everyone. A quick disclaimer before we get into the subject. So we are live on IACC, Indian American Chamber of Commerce. So I request to understand that this conversation is for information purposes only, very generic, not specific to any individual case, and does not create any legal relationship. For any personal consultation and case analysis, please contact us at info.hyderabad@chuk.com. I repeat, info.hyderabad@chuk.com. So we'll be able to help you out. Thank you so much once again for joining the call. So as per the plan, what we did for the day, for today's session. So the first subject we plan to discuss is about the H-1B visa alternatives, exploring options for the skilled foreign workers. So when I say that H-1B, it's subject to visa lottery. So some of the cases may not be selected. Most of the cases, I would say, may not be selected on the lottery system. And sometimes, like if it gets selected also, the case may get denied, unfortunately. So in those cases, like, you people should not be discouraged. And there are a lot of several options also to explore, like non-immigrant options, I would say. But again, the H-1B is kind of a non-immigrant visa that allows US companies to temporarily employ foreign workers in specialty occupation that basically requires theoretical and technical expertise. So the process has to go through the lottery selection. There is no other way that we can do. And maybe like disappointed of not selected or the case gets denied. In such cases, there are a number of H-1B visa alternatives available, each with its own of requirements and benefits, which we'll discuss in detail later point. So the best option for a skilled foreign worker will depend on their individual circumstances. Now, let us now embark on this meaningful journey together. So let us explore what are the options available, if not H-1B. So again, before we get into the non-immigrant issues, like unless you are an Indian or China citizen, you can try for the GC itself directly instead of going through the non-immigrant processing. We'll now focus on non-immigrant work visas, which are alternatives to H-1B. So the first and foremost, what I would like to discuss is the cap exempt H-1B. So generally H-1B is like subject to cap. So there is a possibility that the H-1B can also be filed without subject to cap. So this can be exempted. So this can also be filed with immediate start date without undergoing through lottery system. So basically there are these are 5 universities and related non-profit entities, non-profit research organizations and the government research organizations are exempt from the cap. So these employees can submit an H-1B petition to the USCIS at any time during the year without concern for the fiscal year limit. There is no cap, subject to cap or no limitation on this. So like all through the year, anytime, these can be filed exempting from the cap. And these are the organizations, the non-profit, which I mentioned. So these employees can file the exempt cap petition if they're eligible to file it, including the beneficiary has to be eligible to these roles. And next one, we can explore the H-1B1 visas. So the H-1B1 visa is specific to citizen of Chile and Singapore. Like these people have to be citizen of Chile and Singapore. It allows professionals in specialty occupation equivalent to the H-1B for other countries. So this is kind of for the Singapore and Chile H-1B1 to work temporarily in the United States. H-1B1 is not a dual intent visa and may not apply for a green card while on the H-1B1. Thus can be filed any time of the year, also same as cap exempt petitions. And the next one we can explore and see the E3 visas. So for this also no quota applicable. You can apply any time of the year. So the E3 visa is exclusively for Australian citizens. These are exclusive for Australian citizens. And it's similar to the H-1B visa. The category and the specialized knowledge is similar to the H-1B. But this E3 visa is specifically for the Australian citizens. It is designed for professionals in specialty occupation as well. So basically the specialty occupation requires as I said before, theoretical and practical application of a body of highly specialized knowledge. And of course, the attainment of a bachelor's or higher degree in the specific specialty, or it's equivalent. It can be also equivalent to the US degree, like, when it has been, the document sent to the evaluation. So it has been evaluated to be the US equivalent degree as a minimum for entry to the occupation in the United States. So this visa can be extended every 2 years. So we can see into the IEP startup visa as well. So it's not like a visa actually. I would say it's more like a parole to stay in US. It offers like foreign entrepreneurs another appealing way to start a new business in the United States. It stands for basically IEP is International Entrepreneur Parole. This was meant to be for startups, but unfortunately we are not seeing people using it as much as anticipated. But the purpose of the IEP is to grant a period of authorized stay on a case-by-case basis. So basically it's an investment visa, so obviously it has to be validated on the case-by-case basis to inventor researchers and founders of startup enterprises who demonstrate that their startup would provide a significant public benefit through rapid business growth, but may not yet qualify for the national interest waivers though. An entrepreneur has a substantial ownership interest in a startup entity with an active and central role in the operations of that entity. So basically, due to their knowledge, skills, or experience, the alien is very, they're well positioned to substantially assist the entity with the growth and success of its business. But obviously, for the purpose of this section, like, there is some percentage, like they have to kind of invest at the time of the adjudication of subsequent reparole, at least a 5% ownership or 10% in the startup entity at the time of the adjudication. So these are certain limitations that can go in detail into the subject, if at all, if you choose to this kind of parole visa to enter US. The another non-immigrant visa, what I would suggest is, if it is not selected in the H-1B, the alternative would be the O-1 filing if the beneficiary is kind of eligible to it. So the O-1 visa is for individuals with the extraordinary ability in fields. So the subject would be such as science, arts, education, or business or athletics. So they basically need extraordinary capacity, not only the specially extraordinary capacity. And when I say extraordinary, it is really an extraordinary capacity, and it's a temporary visa. So it requires demonstrating sustained national or international acclaim and recognition. Obviously, like, when we prepare this petition, it will take at least 3 to 6 months sometimes to kind of, gather the information documentation that is kind of equivalent where we can file this O-1 petition. Take some time to file it together and validate all the requirements. But the good thing is we have premium processing available, though it takes time to kind of accommodate and all submit all the documentation. We can file it under premium processing, for the case to get approved within the short period. So the O-1 visa is basically characterized O-1A, O-1B, O-T, O2, O3. I repeat, O-1A, O-1B, O2, O3. So to categorize O-1A are the individuals with an extraordinary ability in the sciences, education, business, athletics. And O-1B is for the individuals with the extraordinary ability in the arts or extraordinary achievement in motion picture or television industry. That is the differentiation between O-1A and O-1B. And of course, O2 are the individual, the supporting team who will accompany an O-1 artist. For example, we see this film artist or stage show people or in a group of people going on the O-1A or O-1B with the extraordinary ability. So they would definitely want some supporting team to accompany them. So those people can go on the O2 visa. So these are the individuals, artists or athlete, to assist in a specific event or performances, like supporting the O-1A or O-1B. And next comes the O3. So these are basically individuals who are the spouse or children of O-1 and O-2 visit holders. So that is the O-1. So now, like, when we have to consider the next category, that would be the J-1 visa. So J1 visa is for individuals participating in exchange visitor programs that promote cultural exchange and international education. It can be used for certain research, teaching, and training opportunities as well. Most of the time, like in my experience, I've seen most of the medical students using the J1 visas for the training sessions, or like to be conducted, or or to be attend the trainings. So the visa is good mostly for training assignment, basically. So the person either gives some training or to undergo some training for so for J1 you work with the sponsored agencies that generally works as J1 sponsors. They are called as J1 sponsors, and they help with the paperwork. It's not a long-term visa. Usually it's 8 months or so, not more than that. So that is about the J1. So we also have E1 or E2 visas comes as part of the treaties. So we have the several treaties with different countries. US has treaties with different countries. So unfortunately, India and China are not part of it for the E1 or E2 visas. So it's not only getting the citizenship of eligible countries, but also the applicant must reside in those countries for at least 3 years before they apply for E2. Majority of countries will be eligible for E1 and E2 visas. These are called as the investment visas. So the good thing about E2 is you don't need a big kind of business. Like, large investments is not required for this. Any small business will do, like laundromats, restaurants, retailers, or cleaning companies. Again, there have to be investment, at least 100K or so. So as India does not have an E2 treaty with the US, India nationals may consider applying for citizenship to another country that has an E2 treaty with the US. Such as people sometimes go to Grenada, Canada, like, in a different visas, and from there, like after gaining the citizenship, work towards citizenship in the USA. So again, so the E2 visa requires a foreign national to invest substantial capital in a new or existing US business. So basically, the E2 visa holder should be directly involved in managing and operating the US business. The E2 visa is valid for 3 months to 5 years, depending on the country of the origin from where the person is coming. And next, let us see the L1 visa. This is most of the people, when the H1 is not filed, this is the most visa by the employer as well as the employees, the L1 visa. So we have different categories on the L1, that is L1A and L1B. And we have the L2 visa for the dependents of the L1A and B. So these are the 3 categories of L visas we have. Alternatively, that can be used if the petition is not being selected in the H-1B category. So this one of the most considered visa, if not H-1B, or with our practice, with our experience, we have seen people jumping immediately to the L1. If they are kind of eligible to file the L1, the employer immediately, because that is the start date is immediate and there is no quota or lottery systems for the L1. So it is designed for intra-company transferees. It allows multinational companies to transfer employees from their foreign offices to a related US offices. Any foreign office outside the US, if they have the office and they have the office in US related office, so the employer will be eligible to pick an employee who is kind of eligible to file the L1 with other criteria that has to be applicable, then they can file the L1. As I initially said, there is 3 L1A, L1B, and L2 categories. So the L1A visa classification designed for intra-company transfers is a temporary visa, non-immigrant category. It's not an immigrant category, it is a non-immigrant category, which allows a person to work in the United States. So obviously it has the maximum time period, which is 7 years for L1A and 5 years for the L1B. So if it is a 7 years for the L1A category, it will be issued for 1 to start. If coming to operate a new business, followed by 2-year extension until max out. So initially it will be given 1 year if the person is going to start a new business in US, and then followed by 2 years extensions until it max out meaning until it gets over for 7 years. And again, if the person is coming to operate a business in the US that has been operating for more than 1 year, then the L1A will be issued for 3 years to start, followed by 2 years extension until it max out. Okay, so to repeat that, like if it is a new office, initially it will be given 1 year and then followed by 2-year extension. So to qualify for this category, a person must show that he or she will be transferred to a US parent company or a branch or an affiliation or a subsidiary or a joint venture of a foreign company for which the applicant has worked at least 1 year, 1 year within the past 3 years prior to entry into the US. So, but of course, there are other additional requirements we have to look into on case-by-case analysis. But this is the basic pro forma that have to be applicable to kind of select a person to file for the L1A. That is the basics. And let us look at for the L1B. L1B is a non-immigrant visa classification that allows an US employer to transfer a professional employee with specialized knowledge in procedures and processing relating to the organization's interests from one of its affiliated foreign offices from outside US to one of its offices in the United States. So basically this classification also allows a foreign company to send a specialized knowledge employee. So when we say the managerial and executive, those people will fall on the L1A category. And with the people like employees with the specialized knowledge with the process and procedures and the skill sets of that company employed to establish a new office. Basically, the employee should have a qualifying relationship also from the outside company and also the US company as a parent company, again, as a branch or subsidiary affiliation, etc. And also doing business or will be doing business after the beneficiary arrives in the US. These are the basic criteria. So when I say doing business means the regular and systematic and continuous provision of goods and services by a qualifying organization, and does not include just the mere presence of an agent or an office. It has to be actually commercially doing business in the form of the organization. So that has to be there. And now at the employee front, so when we say the employee must be employed at a foreign entity for at least 1 continuous year within the last 3 years, immediately preceding. This is the same as the L1A category. Even the L1B, this is applicable, that the employee has to be employed with the foreign company continuous for 1 year within the last 3 years immediately preceding admission to the United States and be seeking to enter the United States. So I think the L1A and L1B is pretty clear, because I'm kind of, detailing more about it because we have seen more people, if not H-1B, L1 is the next one people will look at it. So I think that is the brief explanation of the L1s, where people can be using it if they are kind of eligible to file them, both the employee side and the employee side. Now, let us look at the TN visa. That is, this can be another potential visa, if not the H-1B. And this is available for Canadian and Mexican citizens under the provisions of North America Free Trade Agreement, that is NAFTA. So we have this, US have this agreement between Canada and US and US and Mexico. So under this agreement, it covers certain professional occupations, and applicants must meet specific educational and professional requirements. And as long as their US job offer falls under a list of NAFTA professions, there is a list of NAFTA professions. So the applicant should fall into that category. And the TN visa status is valid for up to 3 years and is indefinitely renewable. So the TN visa is a relatively easy visa because it's most of the time they get this stamped at the border when they at the port of entry, obtain and offers a number of advantages, including a shorter processing time, and the ability to bring your family members with you in the United States as well. And the other one is F1 student visa, but again, it's a student, right? But the best part, like, alternative H1 will be the OPT training period for the F1 students after they graduate. For international students on F1 visas who have completed their degrees at the US institution, OPT provides an opportunity to work in their field of study for a limited period. So these are two types of OPT. There are actually two types. One is a pre-completion OPT and post-completion OPT. So if you're authorized to participate in pre-completion OPT, you may work like, again, 20 hours or less per week while school is in session, or you may work full-time when school is not in session, post-completion OPT. So you may apply to participate in post-completion OPT after completing your studies. If you are authorized for post-completion OPT, you must work part-time at least 20 hours per week or full-time completely. So next, let us look into the H-1B visa. This is also a temporary non-agriculture workers in positions where there is a shortage of US workers. There is a statutory numerical limit or cap on the total number of non-citizens who may be issued an H-1B visa or otherwise granted H-1B status during a fiscal year. Currently, Congress has set the H-1B cap to at 66,000 per fiscal year, with 33,000 for workers who begin employment in the first half of the year. So there is some metrics they follow there. So we can go in detail, like, if you have any questions, you can email us at info.hyderabad@chuk.com to know the metrics on the H-1B visas. So before we get into the next subject, I just want to show a table that shows, like, whether the labor certification is required for this kind of visas, or whether it's a dual intent or cap limit. We can check out and see, like, only the H-1B has the cap limit. Well, let us check this out. Are you able to see the screen?
Yes, sure.
Yeah, so see, these are the few categories, like, type, description, duration, and dual intent. Whether it's a dual intent meaning, like, the beneficiary, whoever is entering US, they should not have the intent to kind of, stay for permanently in US. So like the category shows, like, whether it is applicable, the dual intent is applicable or not. So on labor certification, which the H-1B has, and the cap limit. So if you look at the L1 visa, it's a L1A and L1B, as I mentioned. So this category belongs to A and B. So description is intra-company transferee visa. A is valid to 7 years and L1B is valid for 5 years. Is it a dual intent? It's yes. So you'll be eligible for at the later point to file the green card, and labor certification is not required, and there is no cap limit for this. So when we talk about the lottery system and the cap limit, so it is applicable for the H-1B only. So obviously these would be the alternatives to look at. And the same thing for open visa up to 3 years, and same thing, yes, no, no, and E3 as well, 2 years renewable, and TN visa up to 3 years, and E2 visa 2 years renewable, and no, no, no. And J1 visa, like, varies. Sometimes we may need the labor certification and may not need it. So it's kind of applicable and may not be applicable. So these are the different criteria to know, like, whether it's a dual intent or it is not. So let us go to the next topic for today's topic, and that would be about the open market. So that will be the second topic. Shika, are you able to hear me? Sorry.
Yeah, Sharbila, we can hear you. Only if it can be a little louder, that it's better.
Sure, sure.
Oh, thank you.
Are you able to hear me now?
Yes, yes. Fine.
Yeah, sure. So the second topic what I have chosen for today's brief explanation is like, guide to working abroad and how employees can benefit from open work permit options. So for us, like, whoever is interested to kind of work in the US on the H-1B and what are the alternatives to look at. So it's essential for both H-1B visa holders as well as the employers to be aware of the specific regulations and requirements associated with working abroad or transferring employees to foreign offices. So working with, we would suggest always, like, it's always good to work with experienced immigration attorneys or specialists can ensure, because the compliance with immigration laws, they would be compliant with the immigration laws and regulations in both the United States and the destination country, right? So it's not required, like it's not recommended to kind of individually process on your own. It's always to be compliant and also take the specialist help on that, because this can be causing a lot and also crucial to kind of attend these issues. So additionally, the rules and policies regarding immigration and work permits can change over time. So it's crucial to stay informed about the latest updates from relevant government agencies. So please watch out for those. So every day, like we see like new regulations coming in. So for today night before sleeping, if you study and be prepared for a regulation that is already in the place, next day morning that will not be, there will be some change in it. So it's always good to be on the top of it and take some help with the immigration specialists and attorneys. So now there is a concept called H-1B portability. So meaning H-1B transfer, like portable is like, portable, it's like a transfer. So if you are on H-1B visa holder in the US and you receive a job offer from a new US employer, you may be able to take advantage of H-1B portability. So this means that you can begin working for the new employer as soon as they file a new H-1B petition. This allows you to change employers without having to leave the United. You can transfer from one employer to the other while you're on the H-1B. So we can also look into as global talent acquisitions too. So employees who have the flexibility to hire foreign workers for their international offices through open work permit options can tap into a broader talent pool. So when I say that, this can lead to the acquisition of specialized skills and diverse perspectives as well. So offering open work permit options can increase employee retention and loyalty, as it provides opportunities for career growth and international exposure too. So employers seeking to expand their operations into foreign markets can deploy skilled H-1B visa holders to establish and manage operations in those countries. So very recently, if you look at, we had the open work permit that was introduced by the Canadian government in July 2023. This is very recent. So this setup allows H-1B visa holders to work for any employer in Canada, regardless of the field, like, what kind of field it is. Starting from July 16, 2023, US-based H-1B workers and their immediate family members are eligible to apply for open Canadian work permits of up to 3 years, enabling them to explore employment opportunities with almost any Canadian employer. If you already have an H-1B visa in the United States, you might also very well make the transition to Canadian permanent residence based on your profile and eligibility. So Canada has announced the creation of an open work permits stream for about 10,000 US H-1B visa holders. So the eligibility criteria for this is the applicant with US H-1B. The person has to be in US with the H-1B visa stamp. And applicants who want to advance their career in the North America, and you need to be in the US with the visa. So people who are not in the US but still have the H-1B, they are not eligible for this. So please note that not being in the US and having an H-1B visa is not the criteria, please. So the application process for an open work permit is relatively straightforward and can be completed online also. The application fee is around Canadian dollars 255, to be eligible for an open work permit. H-1B visa holders should have the H-1B visa, as I said, and they must meet the language requirements for the job. But again, overall, like, when I look at it, the regulations and also the process, how it has been quickly reached, I personally felt, I think most of the specialists and the practitioners will agree with the open work permit, such as there is a lot of risk of not getting the employment in Canada. People are rushing, I understand that, and within 2 days, the 10,000 has been filled in. But I personally feel like, there is a risk of unemployment, though people are going it. So even the job market should be open there. So I think better to kind of check in the US and see if, whether the project is available or not, or take it and move to Canada only, like if you think like, at the extreme stage, you're not able to get into any project. But if you see the data, however, the IRCC has reached the cap of 10,000 applications for this initiative as on July 17, 2020. Within like no time, this got filled out and no more applications are accepted. We may have to wait until next fiscal year for any updates on this. So that is the about the open work permit. And we are also facing some issues about the H-1B registrations during the cap cycle. So the third topic, what we have selected, so that people would know what extra precautions they have to take. People meaning the employers, in such a way, like, no more complications they would face while the registrations are going on, even upon the registrations. Obviously, the language they have provided in terms of the uh, registrations may give the leverage for the employers to kind of do the multiple registrations, but to look at the specific legally, it is not acceptable, right? So they have the next year, maybe like, there is certain change in the regulations and also how they frame the statements. Like some people, they like, interpret in their own way and may fight on that. So this is applicable to do the multiple registrations. But I'm sure by next year, like, the USCIS will come up with the new interpretations, and also the way they have stated the statement would may differ from our next year. So people are employers specifically are making advantage of the statement, how it has been framed. So when we look at the United States Citizenship and Immigration Services, introduced the H-1B registration system in 2020 to streamline the H-1B visa application process. As you all know, before it was like directly filing the petitions and then going into the lottery system. But now since 2020, the system has changed, and they have started with the registration initially. So under the systems, employers seeking to sponsor foreign workers for H-1B visas were required to register their prospective employees during a designated registration period. So they have been like in a certain time period um, to do the registrations, and once the date is done, then it will be closed. So after the registration period, USCIS would conduct a lottery to select the registrations that would be eligible to submit full H-1B visa petitions. So after it is selected, then only the employer should file the entire petition. So that's kind of saving the time as well as the work and also the documentation as well. So now for us, it's important to know that USCIS has been vigilant in enforcing the rules and regulations related to the H-1B program. So to prevent abuse and ensure fair and transparent allocation of the H-1B visas. So we need to kind of be very careful not to abuse the system. This includes like cracking down on attempts to submit multiple registrations for the same prospective employee. So the area, the visibility, the kind of, the boundaries, what they look at when they file the H-1B registrations, they kind of, some of the employers are being very selfish and making sure that their employee will be selected when we file the multiple registrations. But we would definitely recommend to kind of think broadly and see like, if it is restricted to one registration for one employee, that the system will be used like broadly with many people, right? So which is like, the whole system, abusing system is prohibited under the H-1B registration system rules, right? So now USCIS is cracking down on multiple registrations for a few reasons, like what to say, to protect the integrity of the H-1B lottery system. So it has to be protected by any means. And also to ensure that H-1B visas are awarded to the most qualified candidates. So when what happens is when multiple registrations are done for the employee, basically it would be the mid-level or the entry level based on the level 1, level 2. Sometimes they may not be a qualified candidates also, right? So at that certain point after the filing is done, it may get denied, but that is a different story. But at the initial itself, when the selection is done, the number is counted towards that specific employee. That means we lost one H-1B, right? So it's basically we need to look whether the qualified candidates are being filed and one for each, right? So to prevent employers from abusing the H-1B visa program also is one of the criteria to be considered. Now, if USCIS identifies multiple registrations for the same beneficiary going for from the same employer and related employers, it may take enforcement actions. So maybe invalidating duplicate registrations, or meaning that the duplicate registrations will not be eligible for selection in the H-1B visa lottery. So, and again, USCIS may impose penalties or sanctions on employers who intentionally submit multiple registration for the same beneficiary to gain unfair advantage on the H-1B lottery process. And abusing system or fraud, USCIS may take additional enforcement actions also, which could include revoking the employee's filing privileges for the upcoming cap cycles and making them ineligible to participate in future H-1B lotteries, or even the criminal charges as applicable may be imposed. So, but in the very recent update, right, however, one of the petitioning employers received a NOID. I said petitioner employer received a NOID alleging fraud and misrepresentation on multiple registration issues. So USCIS identified overlapping registrations for this beneficiary, for this specific beneficiary, along with other candidates with some other company, another company. So among other things, like what their attorney's offices challenged is the USCIS authority to impose an attestation requirement that is not supported by any immigration law or regulation. So they address the issue by pointing out the existing rules that permit multiple registration by unrelated companies. They were specifically stressed out, they pointed out the point saying that this is a unrelated companies. So two different unrelated companies have filed two different registrations. So they were fighting on that when they received the NOID. But remarkably, within a month of submitted the response to the NOID, the USCIS granted approval for the H-1B case for that specific case. But that's what I was stressing, I was kind of, pointing out few things. Do not misuse the interpretation on the rules and regulations and make the multiple legislation. So hopefully for the next cap cycle, the proper rule making process to restrict multiple registration for the next fiscal year. Hope so. So that is about it. So the fourth topic, what we have picked for today's discussion and knowledge sharing is, let us discuss about the top 5 foreign destinations for Indian students. So we from CHUG Hyderabad have started the international students applications. Like we are helping the international students to apply for different colleges from different countries. So if anybody need any guidance or assistance on that, please shoot an email to info.hyderabad@chug.com. info.hyderabad@chug.com. Now, students from India have been increasingly exploring international education options, and several countries have emerged as top destinations for them due to various factors. So the students can check into the quality of education maybe, or the affordability, or the work opportunities, and cultural similarities. Some people, they think, culture doesn't make any difference, but when you go there, if like they have to kind of see whether there is any similarity so that they can survive in that new place. So that can be also one of the category when they kind of look for the opportunities for different universities. So these are the little things that they have to be aware of. So the first country to pick has always been the United States. Like with our experience, we have seen like most of them first pick to be the United States, because it offers a wide range of educational opportunities. And I believe the quality of the education in the United States is world renowned, and the country is home to some of the top universities in the world with number of scholarships and financial and programs available to international students. And the best part is the visa process for the United States is generally straightforward for Indian students. And with the OPT, that is optional training program, also provides opportunities for students to work in the US after graduation. That is the plus point again here. And next we would suggest the Canada. So basically it's the people who are kind of picking up after US and the Canada. Canada has gained popularity as a preferred destination for Indian students due to its kind of welcoming immigration policies and highly quality education as well, and relatively lower tuition fees when compared to the other countries. So Canadian institutions offer a wide range of courses and provide opportunities for post-graduation work through the post-graduation work permit program. They have this program, so that has been kind of market point for them. Then we can consider UK. The United Kingdom remains a destination for Indian students, known for its prestigious universities and also rich cultural experiences. This is one of the selling point for them, the cultural experiences. While the post-study work options were limited for a few years, the UK has introduced the graduate route, allowing international students to stay and work in the UK for up to 2 years of graduation. So after UK, it's the most of them are going to Australia. Australia is another popular destination for Indian students due to its high academic standards and research opportunities and the lifestyle. It's a vibrant lifestyle. So the country's post-study work visa options, such as the temporary graduate visa, which comes under subclass 485, allows international students to gain work experience after completing their studies. And the fifth one they are selecting is the Germany, has also been gaining traction among Indian students, especially in the fields like engineering and technology, and renowned for its technical universities and low or no tuition fees also in many of our public institutions. Germany offers excellent academic programs, if you look at it, and opportunities as well for the research and the internships. So I've seen people going from India also specific only for the internships as well. So other than these 5 countries like New Zealand, Singapore, and Ireland have also been attracting Indian students for their quality of education and also favorable immigration policies. Generally, it's important to know that studying abroad involves various factors and personal preferences. So each student's choice may vary based on their individual goal or financial situation and career aspirations. So additionally, I would say immigration policies and regulations can change. So it's crucial for students to research, which we can help, and stay updated on the latest information from government official sources and education institutions. So as I said earlier many times, like, always the rules and regulation changes very frequently. So it's good to have like, up-to-date information, and always take help with the attorneys as well as the immigration specialists who are experts in this specific category. So we from Hyderabad, Chug office, helping students to reach their educational goals and also giving personalized guidance. Guidance will be provided by our experts, counseling, and dedicated team. So we help you out with smooth admission processing. And we also conduct mock interview sessions as well. So that sense, like all the 4 topics we have chosen for today's discussions. Shika, you want to add anything here?
Yeah. Thank you, Shabila. Thank you for such a comprehensive and detailed session with a lot of information. I think
And also, if I can, take one more minute over here. Sorry about that. So I have, like, we have prepared a list of visas to US from A to Z visas, like, which falls in different categories. If you allow me, I can just go through those lists just to get an idea for the people to, like, what are the A to Z visas come under.
Yeah.
So this is the list, the different temporary visa categories, like, these are the A, B, C, D, E, F, G, H, and how to go down. Yeah, GH and IJK, LMNO, P, Q, R, S, T, UV. These are all different visa categories. In case like H-1B is not working, and these are the alternatives visas that can, sometimes work who are interested to go. So A is like diplomatic employees and their households, and B is business visas, visitors or tourists, and C is the transit visa, C category, and D is for visa, D visa is for crew member, A or Air or C, and E is like, as we discussed, treaty investors or treaty traders, and F1 is students, G visa is employees of international organizations, and H visa is for temporary workers, as we discussed, like H-1B, H-1C, H-2A, H-2B, or trainees H-3. And I is representatives of international media. And the second one is J visa. We discussed about this, exchange visitors. And K visa is for fiancés and spouses of US citizens married abroad. And well, L visa is for intra-company transfers. And we discussed this in detail as well, alternative to H-1B. And M visa is language and vocational students. N visa is for NATO employees. O is for extraordinary ability aliens. And P visa is for athletics, entertainment groups, and Q visa is for cultural exchange visitors. R visa is for religious workers. S visa is for criminal informants, and T visa is for victims of international trafficking in persons, and U visa is for victims of spouse or child abuse, and V visa is for spouses and minor children of permanent residents who are waiting for green cards. So these are like A to Z visas that can be used, that those are applicable whoever is interested, and you want to explore more on those, please reach out to us.
Thank you, Sharmila. Thank you so much for such a detailed and comprehensive address and so much of information. I'm sure members will get benefit out of all the details and all the information what you have shared. I request all the members to kindly share your queries in the chat box. And I think I request any team member from Sharmila's team, if they like to take questions from the chat box, and they can help Sharmila in the question answer session. No problem. I'll go through the questions, and Sharmila, should we start this question answer thing?
Sure, Shika. I opened the chat box. I think one of the question is, can you please highlight on EB5 investor visa? So basically, EB5 investor visa is it's not falling on one of the topics what we have chosen for today's discussion, but absolutely we are open to discuss, because EB5 is kind of like an ocean. It's a very vast subject that cannot be discussed in the yes or no answer. So whoever is kind of, I think it's Sounder, CHO2. Yeah, I think Sounder. Mr. Sounder, you can kind of, take an appointment for the consultation, and we can discuss in detail. It's really a vast subject, cannot be discussed on one statement or one line answer for this.
Okay, then there's a question for Canada, please. Okay, this is reply. There's a question. My son completed masters in supply chain from University of Houston. He's on OPT looking for job. He can't be employed. He can't be employed status more than 90 days. What are the options for him to remain in the US?
What's the name, Shika, who has written the question?
Shakir Umair.
Oh yeah, I got this. My son completed masters in supply chain from university. He's on OPT, looking for job. He can't be unemployed status more than answer. What are the options for him to remain US? So with this question, I understand like he's not getting any equivalent job, like for his studies or anything. But uh, see, for the OPT, as you know, like after 90 days, it's difficult to stay in the country without the employment. But again, the other options is you can either change the status to again to F1 CPT hours, like that there are like CPT subjects where he can kind of enroll in any of the universities. That would be the best option. Otherwise, like we have to go through his entire profile and see whether he can fit in any of the categories what we discussed. As of now on the spot, I would say like CPT F1 status. Otherwise, like we need to kind of validate thoroughly and see like in any of the categories he would fit in, where we can do the change of status for him.
Okay, thank you. The next question is for an employer in H-1B transfer. What is the protection when an employee transfer to a new employer?
So I'm not sure what kind of protection he's looking at, but if it like the transfer is definitely allowed from H-1B transfer from one employer to the other. And again, it has to be the project should be available. The different criteria that we look at while transferring from one H-1B employer to the other. But the protection, like in terms of what kind of protection the person is looking, I'm not sure of. Like we can discuss later in
Can
detail.
I request you to, you can on your audio and you can explain your question and Mr. Sundar?
Yes. The question is, see, as an employer, we are spending a lot of amount and then for the attorney and the visa fee, everything. And suddenly actually you transfer from the present employment to the another company. So even, I mean, say like in many countries, they have a sponsored clearance, no objections like that. It's like that the present employer, do they have any right of, I mean, clearance, or are the employees having their own right to transfer between companies? That's a question.
Yeah, unfortunately, the answer is no. You cannot restrict the employee not to kind of move to the other employer. So since it's a non-immigrant petition, so no employer, they should not even sign up an agreement with the employee to stay with them. So that would be my answer. Unfortunately, there is no yes answer for that. Like the employee is kind of privileged to move from one employer to the other if he has a project available, as long as he's not maxing out and legally stays in the country.
Oh, okay, got it. Thank you. Okay. Thank
You're
you.
welcome. You're welcome.
Next question is, which type of visa required if company wants to depute our representative in USA for a long-term stay, and what is the process?
So this is a very like specific question. So what kind of type of visa for the long stay? Definitely there are some visas. So for example, if I talk about the L1A, it's like 7 years time period, like, with the intermittent extensions in between. And also there are some categories for India, and as well as like apart from India and China also, there are other countries who can gain the green card directly. But for this specific case, like we have to analyze the case, like, once we get the information, we can let them know which category they can fall in, because it's the question is too specific. We cannot give the answer, okay, this is the category the person can fall in. We have to kind of analyze the case and see, like, where the person would be eligible to fit in. Obviously there is long-term visas also, non-immigrant also, as I said, 7 years for the L1A. And for some countries, the person may be eligible for the green card also directly if the dates are current, not for India and China, but other countries. But again, we have to validate the credentials of the beneficiary.
So, Ms. Meenakshi, would you like to share the details online, or you want to get directly talk. Sharmila ji.
Yeah. Yeah, I will share the details.
Okay, sure. We'll share the personal ID with all the participating members. So if you like, you can send your details through an email or you can contact them directly.
Yes.
Thank you. And the next question from Mr. Mahesh is L1 visa or B1 visa holders can do business?
L1 visa, like when we discussed as an alternative for the H-1B, I did mention that the L1 visa for the managerial executive capacity, we can file for opening up a new business, new branch of the existing organization outside US. So we can open a branch or an affiliation or subsidiary as a new office, and we can send the person on the L1A or typically on the L1B if the person is kind of eligible to go and set up a new office and do the operations from there.
Okay, fine. Thank you. And the next question is from Ms. Manju. Can we ask our H-1B employee to give at least 2 months of notice before resigning? Can we ask them to sign the employment agreement with this clause?
Yeah, I think I addressed this question as though like for the first question, like, unfortunately,
Okay.
we cannot restrict the person for signing any such agreements.
Okay, sure. Thank you. And the last question is, can you highlight O visa please?
Yeah, I think we have addressed the O visa, right? Like, well, looking at the alternatives, one of the, and this is, yeah, we can discuss in detail, like, if you get back or like, arrange a consultation. Like basically we can do a different sessions on the visa because it's like a huge subject on its own. Hello.
Okay, Shamila, fine. I think
So anything specific, like, direct answer I can address, but as a whole, like an O visa, as I said, there are 4 categories in it. So it's, yeah.
If we like to ask anything, putting more, adding some detail in the question. Can I request Ramji sir to?
So actually, Shika, we have like very excellent specialist on the O visa. I would suggest to kind of, schedule a consultation to get more detailed information on that. And because to collect the documentation itself and also to check on the eligibility, whether the person is kind of eligible for the O1 or O2 visa, it takes at least 3 to 6 months to collect and file it. And after that, the premium processing is available anyway. The filing wouldn't get delayed. But to kind of analyze the case, like it's a lot of information gathering for that, because to reach to that point of the O1 visa eligibility, it's a lot of achievements have to be made. So we have to kind of check into the achievements and also like prepare the reports for that, like, to explain the achievements and also the gaining knowledge and what are the like awards and rewards the person have gained all through the years. So we need to kind of analyze all those on this.
Sure. So I request any member or guest would like to ask any other question. I think we have finished with the questions in the chat box. Any other question? Then I request you can open your mic and video, and you can ask question if anything is there.
Yeah, for my query, hi, this is Fatima Anwar. For my query regarding my son, how do I go about it? How do I get more information? How can you evaluate the profile? The question I posted was, my son has completed his master's in supply chain, and we are looking for a job.
Hello.
Yeah, I'm listening.
Yeah, she took that question and she replied to that one.
Mm-hmm.
So any other details that you would like to have with that question?
Yeah, as she mentioned that she need to go through the profile in detail.
Yeah.
So how do I request for the next, in detail study of the profile? How do
Sure,
I approach?
Can you write down our email ID, please? info.hyderabad@chuk.com. chugh.com. info.hyderabad@chuk.com.
Okay, got it.
Yeah, we
Thank
will
you.
share the details of the speaker along with the email ID. And if you like to send your details through email, or if you like to contact them, please share your details. And you can talk directly with all the details, your personal details. So that is fine. I think with the all the question and answers, is there, I think one question is there in chat box.
Yeah, I asked, is investing in real estate property considered to be as investment for investment visa?
Yes, yes. The answer is yes. We can consider for-
Buying a house or something like that?
No, buying a house is for your personal interest, right? Like, when we're talking of the investment, then it's something it has to be commercial and business. So buying is a house, like, it's not like doing any favor to the government or not creating the employees in this business system, what you're going to generate, right? Buying a house is like, for your personal thing. But anything that you're going to invest in the real estate that can benefit the area and also the government and also create the employment, generate the revenue in the under the real estate subject, then that can be helpful. We can validate that. But something in your own interest for your personal use, that cannot create a visa. No interest is there.
So does it mean investing in REIT properties like a commercial thing, or how?
Investing in the real estate, yes, we can validate, but specifics to, like, only within your limits, within your kind of budget, and also within your own family interest, that is not considered. So we can discuss offline in detail what is considered as the investment visa in the real estate and how we can approach on the subject.
Okay, yeah, got it. Thank you so much.
You're
Thank you.
welcome.
Okay, thank you so much, and thank you to everyone, and special thanks to Sharmila for patiently answering all the queries and giving
Thank
clarification.
you, Shika. Just announcement, like whoever comes for the consultation through IACC, we'll do free consultation. We will not charge for the initial consultation calls.
Thank you, Sharmila. Thank you. And if anybody, we'll be circulating the details tomorrow. But if anybody needs any other information, please get back to me at my email ID, or you can call me at my number. So we are with the conclusion of this session. I request my Vice Chairman, Mr. Mr. Avinash Chupalli, the Vice Chairman of IACC APTS, to kindly give the vote of thanks. Please, sir.
Thank you, Shika ma'am. Good evening, everyone. I, on behalf of Indo-American Chamber of Commerce, convey a very special thanks to Ms. Sharmila madam for joining us today and sharing her comprehensive information with all our members, and patiently replying to all the queries and answering all the questions. I would like to also congratulate Mr. Ganesh sir, our chairman, for the initiative and organizing today's webinar. Last but not the least, we convey thanks to all our members and guests who have made this possible, and also this session a great success. Any further information, I would request all of you to contact Shika madam for any further information required. Thank you one and all.
Thank you, sir. Thank you so much. And I request all of you, if you have any other thing, you can directly contact Sharmila Garu for the same. And thank you one and all. Thank you for this session. Thank you. Bye.
Thank you, Shika, for organizing this, and thank you to everybody
It's
for attending the session. Thank you.
Thank you, Sharmila. Thank you. Bye.
Bye.